Constitution was to be interpreted in the same way as any other statute and frowned upon any resort to the spirit of the Constitution in derisive and almost epithetical terms. The fortunes of Elman doctrine have been traced in Mudhomi Ntiankolu's Landmarks from Elman to the Saitoti ruling, searching for a philosophy of constitutional interpretation in Kenya. It is no wonder that for long periods of Kenya's post-independence history, constitutional guarantees of freedom and fundamental rights remained for the large part, mere pious platitudes. And I see this as an object lesson for those of us on whom falls the obligation to give meaning to what the Constitution provides. We must learn from the mistakes of history, lest we be doomed to repeat them. It only takes a restrictive, minimalist interpretation here and a textualist, formalist approach there for the spirit of the Constitution to be stymied and its lofty ideals to hemorrhage towards barrenness by a drip drop of near imperceptible clawbacks and innocuous seeming small steps of mark time, slide, and reverse. And I need only add that the Supreme Court has recognized that the 2010 Constitution is a transformative charter to be understood and interpreted as such. In much the same way as new wine cannot be stored in old wineskins, it would be totally illogical to try and squeeze a transformative constitution within the suffocating straitjacket strictures of formalistic or positivistic interpretation. I have no difficulty whatsoever following the fresh and expansive interpretive path blessed for us by the Apex Court in several pronouncements. I've quoted them. I've quoted the Supreme Court in the interim Independent Electoral Commission case. And then in the matter of the Speaker of the Senate, the Supreme Court characterized the 2010 Constitution as having gone beyond the usual parameters of liberal constitutions with its deliberate aim of attaining social change and reform as spelled out in the preamble, part of which I have already adverted to. The aim of that transformative approach is to recognize and reset the interplay of majoritarian and non-majoritarian institutions of the state so as to reach the desired governance goals. It is not difficult to see that such a constitution can ill afford a mean-spirited and narrow-minded interpretive approach, as that would totally negate and defeat its transformative aims of facilitating the socio-economic and political growth of the country. This is identified in the Supreme Court Act, but flows from the Constitution itself and must guide all courts in interpreting the Constitution. I have agreed with the words of Chief Justice Emeritus Mutunga in the Speaker of the Senate and another versus the Attorney General. Only to take perhaps one sentence from there, it is in this context that the spirit of the Constitution has to be invoked by the court as the searchlight for legal illumination and elimination of these legal penumbras. From my analysis of their judgment, the learned judges were faithful to an interpretative scheme that was holistic, cognizant of the transformative character of the 2010 Constitution, purposive, and properly contextual. That approach accords with my own understanding of what the mental orientation of a court undertaking interpretation of our Constitution ought to be, and I would accordingly reject the criticism leveled against the learned judges. I do not accept the attempted denigration of their acknowledgement of the spirit of the Constitution, as if recognition of the spirit of the Constitution was some spiritist, animist retreat to a dark and ignorant or superstitious past. To the contrary, every legal instrument does have a spirit and soul that animates it. Learned authors of Black's Law Dictionary, 11th edition, trace it back to 1802, more than 2 centuries ago, and explain that it is also termed as the spirit of the law and means, quote, the putative intention of the creator or creators of a legal instrument, as opposed to its literal content. This is to be contradistinguished from the letter of the law. And they also treat of the spirit of a letter conception, which is of much recent birth, born in 2014, which they define as, quote, the notion that the spirit of the legal text should prevail over the letter. As far as the spirit of the Constitution is concerned, we endorsed it in the case of the Independent Electoral Boundaries Commission versus Mena Kiage and others way back in 2017, where among other things we said the constitution of a nation is not simply a statute which mechanically defines the structures of government. It is a mirror reflecting the national soul, the identification of ideas and aspirations of a nation, the articulation of the values binding its people and disciplining its government. The spirit and tenor of the Constitution must therefore preside and permeate the process of judicial interpretation and judicial discretion. I believe in those words we were quoting the Supreme Court in the matter of the interim independent electoral commission. We dare say that in the context of the Constitution there is an ever-present spirit that relentlessly pervades its provisions. As a consequence, that spirit, which is always speaking, must be discerned as an integral part of interpreting the provisions of the Constitution. Now, does the basic structure doctrine apply to the Constitution of Kenya 2010, thereby limiting its amendability? The learned judges went through 50 paragraphs of more than 20 pages of history. I do not wish to repeat that history. I've already given I've given a brief overview of the same, but some of the marks of it, some of the high points or low points include the CKRC draft constitution, the post-election violence of 07, Agenda 4, etc., etc. The High Court's engagement with the basic structure doctrine was with that history firmly in view. The case made before them was that the 2010 Constitution contains essential features and critical characters and fundamental values that enjoy transcendental existence, whose derogation is not contemplated in the Constitution by way of constitutional amendments. It thus forms eternity clauses of unamendable provisions. Upon intense analysis, the learned judges pegged their conclusions partly on the people's demand for and insistence upon the direct involvement through conscious and informed participation in the constitution-making process, and I have quoted them. Indubitably, the people were not mere observers or peripheral players in the making of the 2010 Constitution. They were wielders and shapers of destiny, not mere instrumentalities for the formal adoption of a document conceived, gestated, and birthed by the political power elites of the day, only for them to attend and vote at a referendum that would be no more than a ritual naming of a product not their own. The recorded history is crystal clear that the people of Kenya conceived, composed, and constituted their constitution, which they birthed in 2010. And it is only natural, in the way of the Swahili saying, uchungu wa mwana aujuaye ni mzazi, it's the mother who knows the pain of childbirth, as contrasted with my native Kisi saying that mwana vandima miri makendu, another's child is but cold phlegm, that the people of Kenya were very particular that the child of their own making, in which resided their hopes, dreams, and aspirations, as well as a clear statement and architecture of how they wish to be governed, should not suffer the fate of the previous constitution. That other had been amended many times in a deliberate and systematic scheme to quarter it, water it down, dismember, and all but obliterate the promise of freedom for the citizens and limited government that it once had. They expressed their views to CKRC, which I have quoted, and the concerns about constitutional dilution, abrogation, or capture through amendments were also captured. Indeed, they said, considering how quickly and fundamentally the Independence Constitution was amended, how can we protect the new constitution from a similar fate? I'm quoting from the CKRC report. And then they also asked, how can we prevent the decay of constitutional institutions and state organs, as has happened with the institutions of the present constitution, the past constitution? Now, it is a sad blight on Africa's post-independent experience that no sooner did the nations gain independence then the power elites embarked on diluting and dissolving all restraints on power and authority, a blurring and final obliteration of checks and balances and a concentration of power in the presidency. They did this principally through facially legal and constitutionally compliant changes to their constitutions. I have immersed myself in the writings of Professor Nabueze relevant to this subject and taken account of his description in excruciating detail and depressing detail of the manner in which power became so concentrated in the hands of the founding fathers, the heroes of independence, to the detriment of good governance and the rule of law and the liberty of citizens. In Presidentialism in Commonwealth Africa, for instance, he dedicates chapter 5 to the office of the president and starts off under the head, The Extent and Reality of Presidential Power, by pointing out that the most striking feature of the presidency in Africa is its tremendous powers. He goes on to state, which I consider germane to quote in extenso for a full appreciation of the realities that informed Kenya's search for a new constitutional paradigm. He said many things, but just one sentence I will quote there. The Africanness of the presidency in Africa refers to the fact that it is largely free from such limiting constitutional devices, particularly those of a rigid separation of powers and federalism. Now, he talks about aggregation of power, concentration, etc. So, that aggregation and concentration of power, with the attendant creation of imperial presidency, was achieved mainly by constitutional amendments. To achieve them, the restrictions to the amending powers built into the independence constitutions were assaulted and successfully abolished or attenuated. Ghana, the first country to attain independence in 1957, was quick to abolish all the restrictions to amendability, even and especially of entrenched provisions, the very next year by the Constitution Repeal of Restrictions Act of 1958, which was passed strictly in accordance with the prescribed procedure. Thereafter, a simple majority sufficed for every constitutional amendment. The proponents of the abolition of restrictions to the amendment power, including Nkrumah himself, castigated them as a colonialist imposition, an affront to the sovereignty of the new state, and a perversion of the democratic state. I must confess, it did give me an uneasy sense of deja vu when I heard similar arguments made before us in condemnation of the learned judges for deigning to find that there is a limitation to amendment of the 2010 Constitution. Nobueze then recounts